Imagine a cargo ship is sailing in the Gulf of Aden. Suddenly, it's attacked and seized by pirates. Who has the authority to intervene? Is it the country where the ship comes from, the country whose flag it flies, the home country of the crew, or maybe any naval vessel close enough to respond? The answer is surprisingly complex, and it's found in one of the oldest parts of international law, the law of the sea. And how the world polices its oceans, where no single state is in charge, shows both the hidden power of international law and its frustrating limits. So, what exactly do we mean when we talk about international law? At its core, international law is a set of rules and principles that govern relations among states and increasingly other actors like international organizations and individuals. It tells us who can use force and under what conditions, how wars must be fought, who has the right to resources, and what protections people are entitled to under human rights treaties. Unlike domestic law, though, international law doesn't come from a single government. There's no global legislature writing statute, no world police to enforce rules, and no Supreme Court with final authority. Instead, international law is created and maintained through state practice and agreements. In other words, states themselves make the rules, and they decide how and when to follow them. Lawyers and scholars often point to the framework laid out in the Statute of the International Court of Justice. It establishes three primary sources of international law and two subsidiary means for interpreting it. The primary sources are treaties, which are formal agreements between states, like the Geneva Conventions on the Laws of War or the Paris Climate Agreement. Treaties are binding on states that sign and ratify them. Customary international law develops when a state consistently follows a practice out of a sense of legal obligation. Diplomatic immunity is a good example. It's widely respected long before it was ever written into treaty. Finally, general principles of law are broadly recognized legal principles found across legal systems. A common example is pacta sunt servanda, the idea that agreements must be kept. In addition, there are two subsidiary means that don't create law on their own but help to clarify and interpret it. Judicial decisions, like those arising from the rulings of the International Court of Justice, and scholarly writings, or the works of legal experts or academics who help explain and systematize international law. Together, these are the primary and subsidiary sources from which the patchwork of international law is derived. Some are highly formal and codified, like detailed treaties, while others emerge from longstanding state practices or shared legal traditions. But all provide a framework that helps bring order to international politics in the absence of a central world authority. That framework helps answer puzzles like our piracy example. It explains who can act, under what authority, and what obligations states have towards one another on the high seas. But it also raises a bigger question. If there's no world government, why do states follow international law at all? International law is more than abstract rules on paper. It's interpreted, applied, and sometimes enforced through networks of international institutions. While these bodies don't function like national courts or police, they nevertheless provide forums for dispute settlement, accountability, and clarification of legal norms. Arguably, the most important of these is the International Court of Justice, or the ICJ. Often called the World Court, the ICJ sits in The Hague and is the United Nations' principal judicial organ. It hears disputes between states, like border conflicts, maritime boundaries, or treaty interpretations. And it also issues advisory opinions when requested by the United Nations. Its rulings are considered legally binding within certain limits. States must consent to its jurisdiction. This means that powerful countries can, and sometimes do, ignore decisions they don't like. For example, in 1986, the ICJ ruled against the United States' support for the Contras in Nicaragua, but the United States rejected the ruling and responded by withdrawing from the court's compulsory jurisdiction. The International Criminal Court, or the ICC, is also based in The Hague but has a different focus. It tries individuals, not states. Established by the Rome Statute in 2002, it prosecutes individuals accused of genocide, war crimes, crimes against humanity, and more recently, aggression, though in practice, its jurisdiction in this area is still limited. It's indicted leaders from Sudan, Uganda, Libya, and the Democratic Republic of the Congo, among others. But the ICC is controversial. Major powers like the United States, Russia, and China aren't members, and the court has faced criticism for focusing disproportionately on Africa. Still, it represents a historic shift, the idea that leaders, not just states, can be held accountable under international law. And before the ICC was established, the United Nations created temporary courts called ad hoc tribunals to investigate and prosecute specific conflicts. The most notable of these were the International Criminal Tribunal for the former Yugoslavia and for Rwanda. These courts prosecuted war crimes and crimes of genocide from the 1990s conflicts. They help establish important precedents, like defining sexual violence as a war crime, and laid the groundwork for the ICC. And beyond The Hague, there are other institutions that handle specific areas of law. The World Trade Organization has its own dispute settlement body, for example, which hears trade conflicts and can authorize retaliation against violators. And the International Tribunal for the Law of the Sea helps resolve disputes over fishing rights, maritime boundaries, and navigation. These specialized bodies show how international law extends well beyond questions of war and peace, touching on the economic and environmental lives of states. But none of these institutions have perfect authority. They all depend on state consent, and their enforcement powers are limited. But they matter because they provide forums where disputes can be adjudicated according to rules rather than left entirely to raw power politics. And even when states resist, international rulings often carry significant political and symbolic weight, shaping what the international community views as legitimate behavior. International law gives us formal treaties, courts, and rulings, but the global system also runs on something less tangible but equally as powerful: international norms. International norms are shared expectations about what counts as appropriate behavior. They don't need to be written down in treaties to matter. Instead, they work by shaping what states see as legitimate or illegitimate actions. Think of the taboo against the use of nuclear weapons. There is no treaty that absolutely prohibits nuclear weapons. The Nuclear Non-Proliferation Treaty regulates who can have them, but it doesn't actually ban their use. And yet, since Hiroshima and Nagasaki in 1945, no country has used nuclear weapons in war. Scholars argue that a powerful norm, the idea that nuclear use is morally unacceptable and potentially catastrophic, helps explain this restraint. Another example is diplomatic immunity. Even in times of war, states generally agree not to prosecute foreign diplomats. This practice emerged long before it was codified into law because leaders understood that without it, diplomacy itself would be impossible. More recently, we've seen the rise of the responsibility to protect, or R2P. Adopted by the United Nations in 2005, it's not a binding international law, but a political commitment, the idea that sovereignty doesn't give governments the right to massacre their populations, and that the international community has a duty to act when mass atrocities occur. Its application has been uneven, but it illustrates how new norms can reshape expectations about state behavior. Scholars like Martha Finnemore and Catherine Sekink talk about a norm life cycle. New norms often start with entrepreneurs, activists, NGOs, or sympathetic states who push them onto the international agenda. If enough states adopt them, they can cascade across the system, spreading rapidly. Over time, new norms become so widely adopted that they feel natural, even unquestionable, what scholars call internalization. In this way, norms act as a kind of soft law. They don't rely on formal enforcement, but they create powerful pressures of legitimacy. States that violate norms risk being isolated, sanctioned, or shamed by the international community. And in a system without a world government, legitimacy itself is often a crucial form of power. All of this brings us to one of the central puzzles in international relations. Why do states obey international law and norms in the first place? In domestic society, we obey laws, most of the time at least, because there's a government that can punish us if we don't. But in international politics, there is no world government, no global police, no ultimate authority. And yet, most states follow most of the rules most of the time. So why? Realists offer one answer. They argue that states comply with international law only when it suits their interests. International rules, from this perspective, simply reflect the balance of power. From a realist view, international law largely reflects the interests of powerful states. When their interest shifts, compliance breaks down. The United States rejecting the International Court of Justice ruling in the Nicaragua case of the 1980s is a classic example. For realists, the only real enforcement is power, economic pressure, military force, or the threat of retaliation. Liberals see things differently. They emphasize that institutions and law make cooperation easier by reducing uncertainty, setting clear expectations, and establishing systems of reciprocity. Following the rules becomes rational because it builds trust and makes it easier to solve collective problems. Think of international air travel, postal systems, or trade agreements. Without legal frameworks, the system would collapse. Compliance here isn't enforced, it comes out of mutual benefit. Liberals would point to the Montreal Protocol as a prime example. States complied not because they were forced to, but because they recognized a shared interest in preventing a global catastrophe and benefited from a predictable, cooperative framework. Constructivists take yet another approach. They argue that international law and norms shape what states see as legitimate behavior in the first place. States don't just calculate costs and benefits, they also care about their reputation and identity. Violating deeply held norms, like the prohibition on chemical weapons, can bring shame, a loss of legitimacy, and even isolation, even if there's no formal enforcement mechanism. For constructivists, then, states obey the rules not because it's useful, but because over time they come to see those rules as natural, appropriate, or even morally right. For example, constructivists would highlight the global campaign against apartheid in South Africa. In their analysis, sanctions and diplomatic isolation worked not just by inflicting material costs, but by shaming the regime and making its identity as a legitimate state untenable. The reality is, it's probably a mix of all three. States sometimes defy international law in high-stakes conflicts, but in the vast majority of routine interactions, from shipping lanes to diplomatic immunity to trade rules, compliance is the norm, not the exception. That's what makes international law and norms so central to global governance. Even in the absence of world government, they provide a framework for order that most states are unwilling to abandon. So far, we've seen what international norms and laws are, how they work, and why states often follow them. But how effective are they, really? The answer is mixed. International law and norms can achieve remarkable successes, but they also face profound limits. Let's start with the successes. One of the clearest examples is the Geneva Conventions. First adopted in the 19th century and expanded after World War II, they codify rules about the treatment of civilians, prisoners of war, and the wounded. While violations occur, and we often see them in contemporary conflicts, the basic principles are widely accepted, shaping how militaries train their soldiers and how violations are judged. Another success is the Montreal Protocol on substances that deplete the ozone layer. Signed in 1987, it requires countries to phase out ozone-depleting chemicals like CFCs. Nearly every country in the world joined, compliance has been high, and today the ozone layer is slowly healing. This is often held up as one of the most successful international environmental treaties. We can also see progress in the spread of human rights norms. The Universal Declaration of Human Rights, though not legally binding, helped inspire a wide range of treaties, institutions, and advocacy movements. Over time, human rights norms have become central to debates about legitimacy and state behavior, even when enforcement is inconsistent. But the limits are just as clear. Enforcement is often selective, depending upon the interests of powerful states. The International Criminal Court, for instance, has indicted leaders from weaker states but struggled to pursue cases involving powerful actors like the United States or Russia. Critics argue that this double standard undermines the court's legitimacy. Sovereignty also remains a powerful shield. States often resist outside scrutiny, arguing that their domestic affairs are off limits. This has limited enforcement of international human rights treaties, leaving many violations unpunished. And even strong norms can be fragile. The responsibility to protect is invoked in some cases and ignored in others, and that inconsistency raises questions about whether humanitarian intervention is a genuine global commitment or just a tool to be applied where it suits the interests of great powers. The bottom line is this: international law and norms don't eliminate power politics, but they do shape it. They provide standards of legitimacy that states ignore at a cost. They make some actions harder to justify and others easier to pursue. They are imperfect, often fragile, and sometimes abused, but they remain an essential tool of global governance. So let's return to that cargo ship seized by pirates off the Gulf of Aden. Who has the right to act? International law, especially the law of the sea, helps provide an answer. It doesn't guarantee perfect enforcement, but it sets the rules of the road, and those rules matter. They make it possible for navies to coordinate, for courts to prosecute pirates, and for commerce to flow across the oceans. That's the power of international law and international norms. They don't give us a world government, but they do provide a framework for order. They shape what behavior states see as legitimate, and they provide a forum for accountability, as well as giving smaller states tools to challenge stronger ones. At the same time, they have real limits. Powerful states often ignore rulings, sovereignty remains a stubborn barrier, and norms are often applied inconsistently or selectively. International law and norms don't erase power politics, but they do help structure it. And in the end, that's what makes them so central to global governance. They provide just enough order to keep the system functioning, even if they can't solve every problem. But that's it for now. As always, please leave any questions you have in the comment section below, and thanks for watching.